Hello and welcome to Narayana Eyes. I'm Pratik, faculty for Polity, International Relations and Security. Students, in the last lecture we discussed few topics under the theme Judiciary. I hope we have discussed all the topics that we have discussed so far, and I hope you also have downloaded the notes from the description and ensure that you have revised every topic that we have discussed up to until now, right? So today we are going to discuss the remaining topics under the theme Judiciary. Before we proceed with the topics that we shall be discussing today, I have a small announcement. Narayan IS will be introducing shortly 1 year and 2 year prelims cum means integrated program. All those students interested can simply scan the QR code, ensure you fill the necessary information, and our team shall get back to you with all the information required. Right? On this note, let us get started. So these are the 9 topics that we shall be discussing today. The first is the Lok Adalats, right? What are Lok Adalats? The second talks about the impeachment, removal of the Supreme Court and the High Court judges. The third topic talks about the Supreme Court judgment on the private property acquisition. This pertains to Article 31A, also Article 300. Fourth topic talks about the new statute of Lady Justice. The fifth talks about the state of judiciary report of the year 2023. The sixth talks about the Supreme Court judgment on the SC and ST subclassification. The seventh topic talks about the free legal aid given to the marginalized section of the society. Eighth topic talks about the concept of Gram Nyayalay, and the last topic talks about the doctrine of coverture. These are the 9 topics that we shall be discussing, and after the end of these 9 topics, we'll be completing the topics under the theme Judiciary. So students, I hope you are fresh and attentive with pen and book with you to sort of jot down the running notes, right? So let us start with the first topic. What is the context? The context being the National Legal Service Authority, NALSA. This institution recently conducted the third National Lok Adalat of 2024 across different talukas, districts and high courts in 27 states and union territories. 27 states and union territories. This is the concept. Now, it is very important to understand the concept of Lok Adalat. What one understands by the term Lok Adalat. Now see, understanding these topics are important. Why? Because questions have been asked in the examination as it was asked. Okay, I guess I don't mention the question. Anyways, questions are asked on NALSA, then the State Legal Service Authority, District Legal Service Authority, the concept of Lok Adalat. That's the reason understanding such type of topics become very, very important for your examination, right? Now, what are Lok Adalats? Now see, Lok Adalat, by the name it suggests it's people's court. It is people's court. Lok is people, Adalat is court. Now it is a forum. The purpose of the Lok Adalat is to resolve the dispute. This is what the courts are meant for, to resolve the disputes, but without going through the regular court trials, which means without following all the procedure that is followed in the regular courts. So this is the purpose of Lok Adalat, to resolve the disputes without having to go through the legal procedure. And it can also handle the cases that are already in court or those that haven't been formally, let's say, filed in the court. Now, the idea of the Lok Adalat, as we discussed, or rather, we understood that there's no need to go through the regular court. You can also resolve the matter outside. The idea behind the Lok Adalat is to help both the parties, The purpose is to help both the parties to settle the dispute, settle the issue. How? Through mutual agreement. Through mutual agreement, the purpose is to resolve the issue. Now, please remember that the Lok Adalats, they are part of the ADR mechanism. ADR, what is ADR? Alternate Dispute Resolution System. And the aim of ADR, we have discussed this in the last class. The aim is to reduce the heavy load on the Indian judiciary or on the Indian courts. This is the purpose of Lok Adalat. They are part of the alternative dispute resolution system. Now, if I talk about the objective of Lok Adalat, right? As we already have discussed, the main goal of Lok Adalat is to provide fast and affordable justice, because if you go to the regular court, it takes a lot of time, and the purpose to provide fast as well as affordable, not as expensive as going to the regular courts, by avoiding long and expensive procedure of regular courts. This is the purpose objective of the Lok Adalats. And the purpose or the aim of Lok Adalats is to settle disputes in a peaceful way. Where, now see, in the regular courts, it is the case or the judgment is often that one party wins the case, the other loses the case. But here, the purpose is to settle the dispute in a peaceful way, which means both the sides reach an agreement. There's a mutual agreement between both the parties. It's not the case that where one side is winning the case and the other side is losing the case. No. Both of the parties are winners at the same time, losers. Why? Because they are reaching an agreement. This is the purpose of Lok Adalats. This is the objective and purpose of Lok Adalats. I hope you understood the concept of Lok Adalats. Now, talking about the legal status and organization, these points are very, very important for examination. The Lok Adalats are given legal recognition under the Legal Service Authorities Act of 1987. Now, this act says that any decision passed by the Lok Adalat is treated the same as the decision made by a civil court, which means the judgment will be the same as given by a civil court. Now, please remember that the Lok Adalats, right, can be held by different legal bodies. Lok Adalats can be held by different legal bodies. For example, like we have the National Legal Service Authority. At the national level, we have the State Legal Service Authority. Then we have the District Legal Service Authority, and also the Legal Service Committees of the Supreme Court as well as the High Courts, or let's say the Taluka level courts, depending on the situation. Now, these points are very important for your prelims examination. Now, talking about the composition. Now, talking about the composition of the Lok Adalats, each Lok Adalat usually includes a judicial officer. Now, this judicial officer who acts as a chairperson along with one lawyer and one social worker. This is the composition. Judicial officer, one lawyer and one social worker, and this group, it helps both the parties, right, to reach a mutual agreement, mutual settlement. Now, if I talk about the powers and jurisdiction of the Lok Adalats, power and jurisdiction. Now, please remember the Lok Adalat we have discussed has the same power as that of civil court under the Code of Civil Procedure 1908, which means it doesn't mean that as the procedure is not as, let's say, stringent as in the regular court, it doesn't mean that the power of civil court will be more than that of Lok Adalat. No, it has the same powers as a civil court. Now, they can take up various types of cases. Which types of cases? For example, family disputes, compoundable, not non-compoundable. It is compoundable criminal offense which are not that serious, labor issues, bank loan recoveries, housing disputes, and consumer complaints. These are the issues that the Lok Adalats look after. But they are not allowed to deal with serious criminal cases like the murder, let's say rape. Why? Because for serious criminal cases, right, it cannot be settled through compromise. Serious criminal cases cannot be settled through compromise. As a reason, these non-compoundable offences have to go through the regular court. Have to go through the regular court. Now, talking about the referral of cases to Lok Adalat. Now, a case can be sent to a Lok Adalat if both the parties, if both the parties, they agree to settle the case. Or let's say if one party requests it and the other party agrees to it. Or let's say if the court believes that the case can be resolved through compromise, which means the parties have to agree, and if the parties are not agreeing, then they have to go through the regular court. Talking about the proceedings in the Lok Adalat, now it's obvious that the proceeding will not be as stringent as in the regular courts. It is simple and it is informal. The procedure is simple and informal. They are allowed to decide their own way of handling cases, and this procedure actually makes the experience faster as well as more flexible than the regular court proceedings, where the proceedings is, let's say, it has to go through certain fixed procedure. Now see, even though the process is formal, as we discussed, the proceedings are still treated as judicial. As we discussed that the judgment or the judgment, importance of the judgment will be the same as if the judgment is coming from the civil court. Here, though the procedure is informal, though the process is informal, the proceedings are still treated judicial under the Indian Penal Code. Now, we understand this term by the Bharatiya Nyaya Sanhita. As well as it is considered as civil court proceedings under the Criminal Procedure Code, which means the importance of Lok Adalats can be ascertained by the fact that the proceedings, the judgment is given legal recognition, right? And then talking of uh, the decisions of the Lok Adalat. Now, please remember the decision of Lok Adalats. They are final and binding on both the parties. They are final and binding on both the parties. These decisions are treated like a court decree, like judgment given by the civil court, and cannot be challenged. Please remember, it cannot be challenged or appealed in any other court. The decisions are final. Again, a very important point for your prelims examination. I hope you understood the first topic. Right? Now, let us proceed to understand the second topic. Now, this article talks about the impeachment, removal of the Supreme Court and the High Court judges. Now, recently, members of opposition in the Rajya Sabha, they submitted a motion. They submitted a motion. Why? Because they wanted to remove, impeach a judge of the Allahabad High Court. Why? Because the Allahabad High Court had said something which was communal, which could have incited hatred and also led to communal clash. And given that a judge is speaking communal language, did not go well with the opposition members. As a reason, the opposition members, they sort of submitted a motion stating that this judge has to be impeached, it has to be removed. This is the context. Now, talking of the impeachment, questions on impeachment have been asked in the examination as it was asked in the year 2019. You see here a question on impeachment had been asked in the year 2019. So, this explains the importance of the topic. Now, let us try to discuss the constitutional provisions related to the impeachment of the judges in India. Now, under Article 124 clause 4 and Article 217 clause 1 subsection B of the Constitution, the judge of the Supreme Court or High Court can be removed. Here, judge of Supreme Court as well as High Court can be removed on the grounds of proved misbehavior or incapacity. These are the words mentioned in the Constitution. These are the only words mentioned in the Constitution. So it is very important that you remember for the prelims examination. Which means that this constitutional provision ensures that the judges are not removed arbitrarily, right? And it also ensures that the independence of the judiciary is maintained. The independence of the judiciary is maintained. And the detailed procedure for removal of a Supreme Court and High Court judge is mentioned in the Judges Inquiry Act of 1968. This law explains the kinds of misconduct that may justify the removal of a Supreme Court and High Court judge, and which are the cases on the grounds of which Supreme Court and High Court judge can be removed. These are the grounds. For example, misusing the office, committing grave offences that damages the judge's honesty, or let's say violating the Constitution. These are mentioned in the Judges Inquiry Act of 1968, and these two words are mentioned in the Constitution. The difference is something that you need to remember for your prelims examination. So please ensure that you are understanding the detailed procedure. Now, let us go through the detailed procedure of how a Supreme Court and High Court judge is removed. See, start. As I told you, first it starts with the submission of motion. For example, requires a notice signed by, which means first a notice has to be submitted. For notice to be submitted, the notice should be backed in Lok Sabha by 100 members and Rajya Sabha by 50 members. Each and every point step is important for your examination. The second, admittance of motion, which means once a motion is submitted, it has to also be accepted. And who accepts it? The presiding officer. Speaker in the case of Lok Sabha, chairman in the case of Rajya Sabha. They decide whether, though the motion is backed by 100 MPs in Lok Sabha and 50 in the Rajya Sabha, it is still the presiding officer who decides whether to accept it or simply reject it. The third stage, constitution of inquiry committee. Now the presiding officer, he constitutes a 3-member committee including Supreme Court judge, High Court chief justice and a jurist is formed. Again, these 3 members, remembering these 3 members is important for your examination. The fourth, investigation and report. Now this committee of 3 members, they investigate charges and submits report to the presiding officer. They investigate, prepare a report and submit to the presiding officer. Parliamentary approval. Now both the houses pass the motion with the majority of total membership and 2/3, which means now once the report is submitted to the presiding officer, the presiding officer will place the report before the house. Now the house has to vote. The majority required is special majority. Please remember this, presidential order. Now the president issues a removal order upon approval by both the houses. Once the motion is passed in both the houses, now the president formally issues a termination letter or removal order, thereby the judge of Supreme Court or High Court stands to be removed. Stands to be removed. This is how Supreme Court or High Court judge can be removed. I hope you understood the detailed procedure. Now, let us try to discuss the historical instances when a motion was submitted in the Supreme Court or High Court. In the year 1993, Justice V. Ramaswamy was the first judge against whom the impeachment proceeding was initiated. Though the inquiry found, which means the committee found him guilty of misusing public funds, the motion failed in the Lok Sabha. Why? Because the majority, special majority, or the motion could not get approved in Lok Sabha by special majority. In the year 11, Justice Soumitra Singh This is in the year 2011. This judge was of the Calcutta High Court. He faced impeachment after being found guilty of misappropriating funds when he was a lawyer. The Rajya Sabha passed a motion, but he resigned before it could get passed in the Lok Sabha. Then again in the year 2017, impeachment motion was initiated against CV Nagarjuna Reddy of the Andhra Pradesh High Court. The final outcome of the case has not been made publicly yet. So there have been instances of impeachment motion being moved in the parliament, but please remember, so far no Supreme Court or High Court judge has ever been impeached. This is a fact that you need to remember for your prelims examination. No judge so far has been impeached in the history of our country. So this point has to be crystal clear. Now this is another important topic that you need to understand. This is something very important not only for your prelims examination but also for your mains examination. So let us try to understand what exactly is this topic. Now, in a recent judgment, Supreme Court ruled on the limits of the government's power to acquire private property. In the last class, we discussed Supreme Court can acquire private property following a due procedure. But here the Supreme Court is stating that there is a limit on the government's power to acquire private property. If the question is asked whether the government can acquire private property, yes, it should be used. It should be for public use. But again, there is a limit on the government's power. This is what the Supreme Court had stated recently. This was a judgment given in the Property Owners Association versus State of Maharashtra. Here, the petitioners argued the government was using constitutional provisions, which means the petitioners argued the constitutional provisions were misused or twisted to acquire private property. They raised concerns of the misuse of Article 39B and Article 31C. What are these provisions? We'll understand. And so the court made it clear that not all private property can be considered material resources of the community. Now, these terminologies mentioned in Article 39B of the DPSP. The court confirmed the importance of protecting individual property rights while also acknowledging the state's role in promoting public welfare, which means here the court reinforced or confirmed that it is important to draw a balance between protecting individuals' right and also ensuring the government can work for the public welfare, right? Which means government can use the land for public welfare. The government should have the ability to acquire private property for public welfare. This is the context. First and foremost, let us try to understand what is article. See, questions on right to property have been asked in the examination. That's the reason such topics become very, very important for your examination. Okay, now what does Article 39? Because these are the constitutional provisions we discuss in the context, which means the petitioners argue that these provisions are being misused. So, question is, what is Article 39 Clause B? Now, Article 39 Clause B is part of the directive principles of the state policy. What? Directive principles of the state policy. Which means, right, these are the principles that guide the state in creating the laws and policies meant for the betterment of the society. And who drafted these guidelines? The constitution makers. These principles were sort of framed so as to guide the state so that laws and policies can be created for the betterment of the society. Article 39 clause B of DPSP specifically says that the ownership and control of the material resources of the community should be arranged in a way that best serves the common good, which means material resources, the resources of a country, the ownership and control, who owns it, who controls it, should be arranged in a way that best serves the common good. So let's say, for example, if this material resources is entrusted in the hands of the business class, would it lead to common good? No. So here the constitution makers are saying or guiding the state, please ensure the ownership and control of the resources should not be arranged in such a way that should affect the public welfare. But unfortunately, this is what has happened now. I hope you understood what is Article 39 clause B, which essentially means, right, or rather the main purpose of the act is to ensure fair access to resources and prevent a few people from controlling them at the, let's say, at the expense of the common people. This provision reflects the goal of building a just and most importantly, just and equal society. Just and equal society. I hope you understood the essence of the uh, Article 39 clause B. Now, let us try to understand about Article 31C. Article 39 is part of the DPSP. Article 31C is part of the fundamental rights. Now, Article 39 was added to the Indian Constitution through 25th Constitutional Amendment Act in the year 1971. This Article 31C was designed to protect the implementation of Article 39B. This law was brought in, why? To protect the implementation of Article 39B, which means the laws are shielded, protected from being challenged under Article 14, which is right to equality, and Article 19, which is freedom of speech and expression. Which means Article 31 says that, or states that, if a law is brought, if the parliament makes a law to implement Article 39 clause B, and if the law violates Article 14 and 19, which is fundamental rights, which means in order to enforce a directive principle of state policy in pursuit of so, if the law violates Article 14 and 19, then in such a case, the law should be untouched, which means should be declared constitutional. It should not be declared unconstitutional because it is violating Article 14 and Article 19 fundamental rights. The purpose of this Article 31C was to protect the implementation of Article 39 clause B. The aim was to allow the government to create economic and social reforms. Economic and social reforms, how? By framing a law, So by framing a law, the government intends to redistribute wealth and also regulate the property. This was the purpose. But the Article 31C has faced scrutiny, which means has been challenged it has been challenged many a times. Now, the Supreme Court, especially in the Keshavanda Bharati judgment of 1973, and also let's talk about the Keshavanda Bharati judgment. The Supreme Court upheld the idea behind Article 31C. So here the Supreme Court actually upheld, said that Article 31C is constitutional, but then it also introduced the concept of basic structure doctrine, which means that no law, including the one that is made under Article 31C, can violate the basic principles of the Constitution. Yes, you can frame a law, but it should not violate the basic principles of the Constitution, and if it does, it will be declared unconstitutional. This actually limited the scope of protection given to Article 31C, which means again the Supreme Court will individually assess whether the law framed to implement 39B under Article or through Article 31C is violating the Constitution or it is not. Also, the Supreme Court in the Minerva Mills case of 1980, in the Minerva Mills case of 1980, the Supreme Court went further and ruled that Article 31C cannot be used to protect all the directive principles from judicial review. The ruling ensured that there must always be a balance between what? Directive principles and fundamental rights, and that the courts must remain free to review any such laws which violates the basic principles of the Constitution, or let's say the fundamental rights. Essentially, the essence of what we discuss is that yes, the parliament can bring a law to implement directive principle of state policy, especially here Article 39B, but the court will individually assess whether it is violating the basic structure of the Constitution or it is violating the basic principles of the Indian Constitution. Now we'll also discuss the constitutional provision related to right to property. Talking about Article 31 now, please remember the article originally recognized right to property as a fundamental right. Right to property was considered as a fundamental right, but it was repealed in the year 1978 through the 44th Constitutional Amendment Act. Right to property ceased to be a fundamental right through 44th Constitutional Amendment Act. After this change, right to property became a constitutional right instead of a fundamental right. The second is Article 31A and Article 31B. Now, these two constitution or provisions were added through the first Constitutional Amendment Act in 1951. The purpose of 31A and B was to support land reform laws, which means the government should be in a position to acquire private property and redistribute among the needy section. The purpose was to support the land reform laws and to protect them from being challenged in the court for violating fundamental rights. Which means, let's say, if I have, let's say, 200 acres of land, the government will acquire land from me and redistribute among the landless. This is what the land reform laws talks about. Article 31B, it introduces the ninth schedule, which means any law placed under the ninth schedule cannot be ever challenged. It is shielded from the concept of judicial review. Article 300A, now this after Article 31 was repealed, Article 300A was added to the Indian Constitution, which means the right to property remains a constitutional right. It is no longer a fundamental right. It is a constitutional right and states that no person shall be deprived of their property. This is the constitutional right. Person will not be deprived of their property except by authority of law. Meaning that the government has to follow a legal procedure. Whenever the government is acquiring a land, the government has to follow legal procedure and thus acquire the private property. But the private property, the use of private property should be for public good. This is what the Supreme Court, this is what Article 300A is all about. So I hope you understood the different provisions associated with right to property. So if this concept is not clear, I request you to please go to the basic, right? Please read Article 30, Article 31A, B, C, please understand the directive principle. Article 39B, 39C, please read the judgment or the outcome of the Supreme Court in the Minerva Mills case, in the case of the Bharti case. Everything is mentioned in Lakshmikant. So please go through these basics so that you'll be in a position to understand the development happening. Okay. Now, next topic, new statue of Lady Justice. I hope you all know that the Chief Justice of India recently unveiled a new statue of Lady Justice in the Supreme Court premises, right? But in this article, it is important to understand what the new Lady of Justice stands for. Is it the same as what the old Lady of Justice represents? So this is what we need to understand. Now, let us discuss about the state statue of Lady Justice. Now, the statue of Lady Justice, right, is a well-known symbol of, or is a well-known symbol used across the world to represent the judicial system. This Lady Justice is used across the country to represent the justice system. This lady, she stands for important values like fairness, impartiality, and the rule of law. This lady symbolizes the principles of fairness, impartiality, and the rule of law. Now, these are the key principles. These three are the core principles that form the foundation of any legal system that aims, or that the purpose is to deliver justice equally for everyone. So these are the core principles on the basis of which the edifice of the legal system is constructed. Now, the figure or the statue of Lady Justice comes from the Roman mythology. In the Roman mythology, this Lady Justice was known as the goddess of justice and law. Her image is often shown as holding a sword, scales, and sometimes wearing a blindfold. Now, please remember all these three things: sword, scales, and blindfold. It symbolizes different elements of justice. Which means, for example, if I talk about sword, now this sword, it stands for enforcement, and authority. Sword, it represents enforcement and authority. The scales represent balance and equality. The scales, it represents balance and equality, and blindfold shows that justice should be impartial. Justice should be impartial, that is, there should be no bias, no prejudice. So, sword, scales, or blindfold, what it represents can be asked in the examination. That's the reason you should be prepared. Talking about India, in India, this image of Lady Justice, it became more widely used during the British rule. Why? Because it is the British who introduced the modern legal system in our country. And during the British rule, the Lady Justice, her statues were placed before the courtrooms as a symbol of judicial authority. Over time, her figure became familiar to the Indian public and legal community. Why? Because it symbolized the promise. It symbolized the promise of justice under the Indian Constitution. Under the Indian Constitution. So, with respect to this topic, what the Lady of Justice symbolizes, stands for, as per the Indian meaning, context is something that you need to understand. So please remember this: in justice, fairness, impartiality, rule of law, sword, what it represents, enforcement and authority scales, and also blindfold. So again, if here you can see the difference. For example, the old lady, it was added during the Renaissance, that is the 14th century, as a possibly as a satire on judicial corruption. We do not know. It's a old story, right? So it reinterpreted during the Enlightenment to signify impartiality, ensures justice is blind to wealth, power, or social status, ensuring fairness. Talking of the new Lady of Justice, it is not blindfolded, which means the eyes are open. It represents that law. It sees everyone equally. It acknowledges what? Social diversity and discrimination. So here you can simply quickly go through the difference. Again, I request you to please download the notes of this topics from the description, from the link given in the description. Make sure that you are revising, remembering the difference. Again, you do not have to by heart. You just have to go through it, gloss over it twice, thrice. That will be more than sufficient to remember, so that you can recollect in case a question is asked on this particular topic. The next topic, a State of Judiciary report. The Supreme Court of India recently released the State of Judiciary report, highlighting the important issues relating to the functioning of the judicial system. Now here again, this topic I want to read by your own, because there's nothing much to explain in this article, right? For example, here if you see, it talks about the infrastructure gaps, it talks about the judicial vacancies, it talks about the gender representation, the statistics, technology and digital infrastructure, budgetary allocation issues. So there's nothing much to explain, but yeah, the statistics mentioned is important not only for your prelims examination, but also for your mains examination. You may get a question, right? For example, in budget 23-24, the Ministry of Law Justice received this many crores, which is just 0.1% of the total budget. They may ask, okay, the money given to the law and justice is, let's say, 0.5% of the total budget. Is incorrect. It's 0.1. They may give you 1%, 2%. The answer is 0.1%, which means it is just a minuscule number, right? So only 57% of the courtrooms are equipped with video conference. They may say 80%. So they may confuse you with any number. So a basic number, statistics is something that you need to remember. And these are the initiatives that the government of India has undertaken to bring reform in the judicial system. For example, we have the National Judicial Data Grid. It provides real-time update on the case status across all the courts in India. Then we have the e-court service portal. Then we have e-filing faster system. Then interoperable criminal justice system. Now the interoperable criminal justice system, what it does is it actually connects the judiciary with the police and other law enforcement officials. Interoperable, this is interoperating between judiciary and the police and the law enforcement agencies. And the purpose is to ensure seamless data sharing between judiciary and the police, and this helps in quickly processing of the criminal cases. Next question. Now the next question, it talks about the Supreme Court verdict on the scheduled caste and the scheduled tribe subclassification on the question of whether the SC and ST can be divided into smaller subgroups, that is smaller subgroup within SC and ST as well, for the purpose of reservation has been a significant issue. Now, this issue gained new importance after recent Supreme Court judgment that allowed states, which means now the Supreme Court has allowed the states to subcategorize the scheduled caste and the scheduled tribe community. Which means, let's say for example, the scheduled caste is given, let's say 10% reservation. Now, this group can be subcategorized, and who can do this? The states can do it. The goal is to ensure the benefits of affirmative action. What is affirmative action? Reservation. Reach those who are most disadvantaged. Which means within the SC category, right, by providing reservation to the most, let's say, disadvantaged community, or most, let's say, a vulnerable community, the purpose is that we are actually helping the benefits of affirmative action to reach to the most disadvantaged group. Now, questions on reservation have often been asked in the examination, as it was asked in the year 2019. So, questions are often asked. Now, the first and foremost thing that we need to understand is the concept of subcategorization, which is also referred to as subclassification. So, what is subcategorization or subclassification? Subcategorization, which means dividing a larger community such as SCs or STs into smaller subgroups, and this is based on their specific levels of social or, let's say, economic backwardness. And what is the idea? The idea is that not all communities within the scheduled castes and the scheduled tribes are equally placed or are equal. Now, this we discuss why, because some groups might have benefited more from the reservation within the SC category. So, let's say there are 50 groups, 20 groups may have benefited more than the remaining 30 groups, and the other 30 groups, they remain marginalized. And that's the reason subclassification is intended to distribute the benefits of reservations more fairly. It targets those who have been left behind with the or left behind within the reserved category. So, this is the purpose behind the subcategorization of the SCs and STs. Now, let us discuss the constitutional provision, Article 341 and 342 of the Indian Constitution. Now, this debate around subclassification is not new. It is closely linked to India's history of caste discrimination. It is linked to India's history of caste discrimination and also the policies of the affirmative action introduced to address the social inequalities in our country. And for the very same, the Constitution of India has provided reservation for the scheduled castes and scheduled tribes under Article 341 and Article 342 of the Indian Constitution. Why? Because these two articles, it empowers the president. It empowers the president. This is the constitutional mandate. It empowers the president what? To notify certain castes and tribes. The president will notify certain castes and tribes, right, as scheduled castes, scheduled tribes, and then it will allow the parliament to amend these lists. Who will amend the list? The parliament will amend the list. Now, there are two Supreme Court judgments, which is very, very important. Why? Because these Supreme Court judgments have actually shaped the legal conversation around this issue of subcategorization. First is the E.V. Chinnaya versus State of Andhra Pradesh case of 2004. And how this case is different from this case we'll understand once we understand these two cases. Now, in the first case of 2004, that is E.V. Chinnaya case. Now, in this case, the Supreme Court actually ruled that subclassification within the SCs and STs is not allowed. The court said that these groups must be treated as one unit and any internal division would go against the concept or principle of Article 14. It held that once a caste is listed, SC or ST in the presidential list, all the members of that caste should be treated equally for the purpose of reservation, which means, in short, the Supreme Court did not allow for sub-categorization or sub-classification in the E.V. Chinnaya case of 2004. And then in the year 2020, the Supreme Court overturned its observation in the year 2004. Now, this case actually brought a shift in how the Supreme Court started looking at the issue. Why? Because by 2020, the court acknowledged there are inequalities even within the SCs and the STs. And then it suggested that this case, it requires overhauling. And as a reason, the Supreme Court re-examined the issue. It recognized that some communities may have received more benefits from reservation than the others. And as a reason, sub-classification could be considered to correct this imbalance where few groups have benefited at the cost of others. And in this light, the Supreme Court's 2024 ruling becomes extremely important. Now here, a seven-judge bench led by former Chief Justice D.Y. Chandrachud, he gave a major judgment which actually upheld the validity of sub-classification within the SCs and STs. In the 2024 judgment, the court, it actually overruled the judgment given in the E.V. Chinnaya case. It states that states do have the power. Every state has the power to create subgroups within these SC and ST categories. The purpose to ensure that the most backward among the SCs and STs get fair, they get benefits from the reservation policy, affirmative action. Now the judgment was given 6:1. So 6 people agreed with the judgment, 1 did not agree. The majority opinion, what did they say? They held that sub-classification is allowed under Article 14 of the Indian Constitution. Why? Because it promotes substantive equality. It promotes substantive equality over formal equality, or let's say legal equality. The 6 judges, they said that the decision to sub-classify should be based on data and facts is still open to judicial review. Which means whenever you say that, okay, this category is the most backward, then it has to be substantiated by data and facts. They agree that not all the communities within the SC or ST are equally backward, and that's the reason treating them all may actually result in inequalities. That's the reason sub-classification is allowed. But then one judge did not agree with the majority opinion. Her name was Justice Bela Trivedi. She was the only dissenter. She disagreed with the majority opinion. She warned that allowing sub-classification could lead to further division among the SC and ST categories. It can weaken the purpose of a unified reservation policy. And she also stressed that the presidential list of the SCs and STs is final and states should not be allowed to divide or let's say subcategorize or let's say subclassify them. But however, as 6 judges, concurred with this judgment, which means now the states have the power to subclassify or subcategorize the communities within the SCs and STs. This is what you need to understand about this particular topic. I hope you understood. Now, next topic, free legal aid. Here, the Supreme Court has recently issued important directions to the legal service authorities to improve access to free legal aid, especially for prisoners. Free legal aid. The goal is to make sure that every person, regardless of their financial situation, has the access to legal help and demand justice from the system. So this talks about free legal aid. Now see, question on the National Legal Service Authority, whose help is to provide free legal help, was asked in the examination in the year 2013. So such topics, it becomes very important to understand for the sake of, or from the perspective of examination. Now, what do we understand by the term free legal aid? What is free legal aid? Means providing legal help to whom? To those who cannot afford a lawyer. Can poor people afford a lawyer? No, they cannot. Which means when it comes to free legal aid, it includes legal advice, representation in court by the lawyer, help with the paperwork, and assistance throughout the entire legal process. This free legal aid, it ensures that justice is not denied just because someone is poor. And then this right to free legal aid has actually grown through important court decisions. For example, now this is something it is very important to understand. One of the famous judgments in the Husainara Khatun versus State of Bihar case. Right? In this judgment of Supreme Court, the Supreme Court ruled that state is responsible for providing free legal aid to ensure fair trials in our country. It reinforced the duty of the state to provide free legal aid. Then, according to section 304 of the Criminal Procedure Code, if a person accused of a crime, if a person accused in a crime cannot afford a lawyer, then the court must assign one. And who will provide this? The state will ensure that the accused person is getting a lawyer too, so that his case, his side of the story is also heard in the court. In another case versus the Khatri 2 versus State of Bihar. Again, don't remember this case is important, so I request you to remember this case, but this is not important to remember. Here in the Khatri 2 versus State of Bihar, the court stated that the legal aid must begin right from the accused first appearance in the court and continue through the entire period. Right from the accused person's first appearance in the court. Then in the Madhav Hoskot versus State of Maharashtra case, again here the Supreme Court said that it was held, or the Supreme Court held, that even for filing appeal, a person is entitled to legal assistance. Let's say a judgment has been provided by a lower court. Now a person wants to appeal this in the higher court. Even for that appeal, legal assistance must be provided. This is something very, very important that one has to understand and remember. Now here, the right to get free legal help, was actually linked to the constitutional provisions. It is tied to two fundamental rights. One is Article 14, the other one is Article 21 of the Indian Constitution, which actually ensures or promises equality before the law. And here Article 21 talks about right to life and personal liberty. Again, referring to the Husainara Khatun case, here the Supreme Court connected legal aid as part of Article 21 of the Indian Constitution, said that free trial is part of right to life, under Article 21 of the Indian Constitution. It also highlights the importance of Article 39, which is a part of directive principle of state policy. Here This Article 39, it actually nudges, it urges the state to provide free legal aid to ensure that justice is not denied because of, let's say, social or, let's say, economic reasons. Doesn't matter if you're a rich person or poor person, if the situation demands that you be provided a lawyer, then the state has to ensure that you do get a lawyer so that your case is heard in the judiciary.
अच्छा ये जो बॉर्डर है
Okay. Now students, let us, once we understood the constitutional provisions which actually provides for free legal aid, we'll also try to understand the institutions that are responsible for providing free legal aid. So, now if I talk about, see, the free legal aid help is provided at different levels. So, if I talk about the national level, it is the National Legal Services Authority. It manages a system, and at NALSA, it is the Chief Justice of India who is the patron in chief of NALSA. So please remember this fact for your prelims, that it is the Chief Justice of India who is the patron in chief of NALSA. Very important point for your examination. At the state level, we have the State Legal Services Authority. Again here, this state level service authority is headed by the Chief Justice of that respective High Court. And then at the district level, we have the District Level Service Authority. This is under the leadership of who? District Judge. Then the Taluka Legal Service Committees, right? This committees, it is led by Senior Civil Judge. Senior Civil Judge. Now, in the chapter on subordinate courts, the hierarchy of courts and the hierarchy of judges is given. This actually works at the taluka level. Then, other than this, we also have the legal service committees. They are actually set up in the high courts and the Supreme Court, and the purpose is to provide assistance at that particular level. And what about the eligibility for free legal aid? Does each and everyone get help? No. So people who are eligible to get help under the Legal Service Authority are the SC, ST, women, children, persons with disabilities, victims of natural disasters, violent survivors, industrial workers. So these are the people who are eligible for free legal aid. Now in this context, let us also try to understand about NALSA. National Legal Service Authorities. This was created in the year 1995 under the Legal Service Authorities Act of 1987. The purpose is to provide free legal service across our country. Now, NALSA has actually taken many steps to ensure that the excessive has taken many steps to ensure that the access to justice is expanded. For example, it has set up almost 1,256 prison legal aid clinics across the country since 2023. It has helped over 3.2 lakh prisoners with legal support. In 21, it introduced legal aid defense counsel system ensuring continuous legal support who cannot afford private lawyers. Right? Then at the same time, the Supreme Court also issued certain guidelines so that people actually get access to free legal aid. For example, the Supreme Court said that in order to make free legal aid more effective, more reachable, the Supreme Court directed the authorities at national, state, district, taluka level to raise awareness. And how do you raise awareness? Through creative methods like, let's say, street plays, posters in the police station, notices in the post offices, and let's say at the same time you're displaying at the transport hubs. Then information should also be shared in local language so that it is more and more accessible. Also, to improve the service, the court recommended that there should be regular communication between the jail visiting lawyers and the prisoners. This is very, very important for the ongoing trials. And then at the same time, it is important to digitalize the NALSA system so that real-time tracking of cases, legal cases, is possible. And also, the court also emphasized the importance of early legal help by strengthening early. Here you see early legal help by strengthening the early access to justice program under NALSA. All right. So this is what the Supreme Court suggested. The purpose is to basically protect the rights of the accused even before their trial begins. And finally, the court also, called on all the legal service authorities at the national level, at the state, at the local level to keep working actively to ensure they are working so as to achieve the goals set out in the Constitution of India, that is to provide, especially under Article 31, right to free trial, right to justice as per the constitutional mandate. I hope you understood this article. The next article. The Supreme Court of India recently expressed concern about how practical it is to set up Gram Nyayalayas or village courts across the country. Now, this concept of Gram Nyayalay was introduced under the Gram Nyayalay Act of 2008. The purpose was to bring justice closer to rural citizens. But the implementation is a problem. Now, question on Gram Nyayalay has been asked in the examination as it was asked in the year 2016. As it was asked in the year 2016. Now, let us try to understand the concept of Gram Nyayalay. What are Gram Nyayalay? Now, the Gram Nyayalay, which means Gram, that is village, Nyayalay is court. It is nothing but it is village level court. Gram Nyayalay is village level court. These village level courts, they are created to offer quick and affordable justice to people, especially living much away from the regular courts. Now, this idea, for the first time, the idea of Gram Nyayalay was given by the 114th Law Commission report, right? And this law, the Gram Nyayalay Act, was enforced in the year 2009. Gram Nyayalay Act was enforced in the year 2009. Now, what is the main aim? The main aim is to deliver justice at the doorstep of the rural citizens without any delay, or let's say without incurring any high expenditure. Without incurring any high expenditure. Now here under the Gram Nyayas, it is the responsibility of the state government. It is the responsibility of the state governments. Every state government will consult in consultation with the High Court, will appoint a Nyayadhikari. Nyayadhikari is who is he? Is a judicial officer with powers of first class judicial magistrate. Which means please remember that there will be a Nyayadhikari for each and every Gram Nyayalaya. And these Nyayadhikaris, their purpose, what is their purpose? Their purpose is actually to ensure that they visit different villages. They're expected to run mobile court, which means they actually take the judiciary at the doorsteps of the rural citizens. This is referred to as mobile court, which means they visit villages, they hear cases on site when it is most demanded by the people. Which means in simple terms, Gram Nyaya is a concept where justice is taken at the doorstep. The courts are mobile, which means the Nyayadhikari, the team of Nyayadhikari visits different villages, hears their cases, and then also dispenses justice. Now again, this is important. This act is applicable across the entire country except for Nagaland, Arunachal Pradesh, Sikkim and the tribal areas under the 6th schedule. Now which states fall under 6th schedule? Assam, Meghalaya, Mizoram and Tripura. So these are the 4 states that fall under the 6th schedule of the Indian Constitution, which means yes, it is applicable across the country, but there are some exceptions as well. So 6th schedule, please remember 6th schedule. Now, let us discuss few features of the Gram Nyayalaya Act. Now, the Gram Nyayalayas, they are generally set up at the intermediate panchayat level, that is at the taluka level, at the block level. They are set up at the block level. Now, Gram Nyayalaya will be constituted for a group of nearby panchayats, that is villages. The headquarters of Gram Nyayalaya is at the block level. And then it is from the block level, the Nyayadhikari travels to villages under the jurisdiction to hold the court sessions, which means sessions are held in the villages. So every block level has, let's say, has jurisdiction over defined villages or let's say panchayats. Now these courts, they handle both civil as well as criminal cases. Very, very important point for your prelims examination. It handles both civil as well as criminal cases. Now this Gram Nyayalaya, right, this law actually encourages parties to settle their disputes through conciliation. Conciliation, arbitration. Now in the chapter topic that we discussed the other day, we also discussed the concept of conciliation where compromise is done. This conciliation with the help of conciliators will help both the parties, right? And these conciliators are also appointed by the court. They will help both the parties to reach an let's say agreement. Right? And then and please remember that the Gram Nyayalayas are not strictly bound, let's say, by the code of civil procedure, criminal procedure code. No. They follow the principles of natural justice. They follow the principles of natural justice, which means there's a high degree of flexibility when it comes to handling different types of cases. This procedure, it allows these Gram Nyayalayas to function more, let's say, having more flexibility, and through this flexible approach, they can ensure that they're accessible to, let's say, the poorest of poor person in our country. Which means if you talk about the characteristics, the features, it seems that such a noble idea. But the problem is with respect to implementation. Now, since the law was enacted, 15 states have taken steps to implement Gram Nyayalayas by officially notifying 481 Gram Nyayalay courts. However, only 309 Gram Nyayalayas are functional, and these operate in just 10 states. These operate in just 10 states. 15 states, yes, they have implemented, but in reality, it is operating in 10 states. Now, this actually shows the gap between law and the actual implementation. So, I hope you understood the concept of Gram Nyaya. And then this brings us to the last topic of the day, which is the doctrine of coercion. Now, here the Supreme Court is now preparing to hear petitions challenging the marital rape exception under both the IPC and let's say and the newly, that is BNS. This challenge brings into focus the outdated doctrine of coercion. Now, question, simple question can be asked. For example, doctrine of coercion recently heard in the news is or is applicable to which of the following? You'll get four statements, four options, you have to choose one. So you just need to understand what exactly is doctrine of coercion. What is the doctrine of coercion? Now, this doctrine of coercion was a legal principle taken from the English common law. It viewed married women as being legally covered or protected by their husbands. It tied the identity of a woman to that of her husband. In practice, this meant that legal identity is merged with that of her husband after marriage, which means after marriage she would lose her identity. Why? Because her identity will be attached with that of her husband. So, which means, see, under this doctrine, a married woman had no independent legal status, which means she couldn't own her property or couldn't own a property in her own name. She cannot sign any legal documents. She cannot enter into any contracts or even file legal cases without the approval of her husband. Which means all of her property and earnings were considered to belong to her husband. This effectively meant that marriage suspended, let's say if the marriage gets suspended, it's a divorce, many women would lose their legal right. They lose their earnings, they lose their property. And this actually reflects what it reflects. It reflects how the structure is devised so as to take away the rights, independent stature rights of a woman. This shows how the patriarchal nature of a society is deep rooted. Now, yes, India, we know, has made progress in recognizing the legal rights of women. But then there are some outdated ideas like this doctrine of overture that still exists, such as the marital rape exception. And that's the reason the courts, now the court is actually looking after the matter. Which means now the court's upcoming judgment, it could actually play a very, very important role in ensuring equality and legal recognition of the autonomy of women, that is her identity even post marriage. So this is the doctrine of coercion. I hope you understood the concept of doctrine of coercion, and this brings us to the end of the topic under the theme judiciary. So we have discussed close to 20 topics under the theme judiciary. In the other day, we discussed few topics, and then today we have completed all the topics under the theme judiciary. We are quickly pacing through through all the topics under the subject polity. Students, I request, if you really want to get good marks in your prelims examination, then please make sure that you are downloading the copy from the link mentioned in the description and you are revising it. Once you have sort of given time to understand all the topics, revision revising all the topics we have discussed will not take more than 30 minutes of your time. So please invest 30 minutes of your time so that you are free from any confusion, any doubt as with respect to clearing the pre-examination or getting good marks or ensuring that you are in a position to attempt each and every question pertaining to polity current affairs. We are investing a significant amount of time, as well as we are doing everything to provide you with the best quality material, all in written. We request, we expect from you is to please ensure that you are sort of uh, spreading spreading the video, ensuring that you are actually informing your aspirants, fellow colleagues about our initiative, and make sure that you bring those people who are in need of quality content, bring them on a channel, make sure they are subscribing to our channel, and make sure that they understand the things that we're discussing in the class, because this will immensely help in the examination. On this note, I call it a wrap. Thank you so much for watching.